Justice Jackson.
Can I just quickly point out that in response to Justice Alito, he asked about whether or not there could ever be a categorical rule that scores alone are enough, are or are not. And I guess I'm just worried about the clinicians and the people who try to evaluate this condition. And they seem to be saying, I'm talking about the amicus briefs here of the American Association on Intellectual Disabilities, that there are, quote, too many variables to consider in determining the validity of each test score and the convergence of that score with other scores and qualitative information to rationally support the use of only one procedure. They seem to be saying that you've got to look at a lot of different things in order to come to the truth of whether or not this person is actually intellectually disabled. It's not enough just as a clinical matter, as a sort of outside of the context of the case. If we're really trying to get to the bottom of this, you have to look at a lot of things. And I thought that was the thrust of the court's conclusion, that you don't cut people off just because they have a particular test score, that you allow experts to evaluate everything and the court to weigh everything in making this assessment.
That is, in fact, what all clinicians believe. But of course, there are clinicians who would testify, who would, and in fact have testified in Alabama cases, that there was one case, I'm forgetting the name of it, where the test score was 69. There was only one test, it was 69, and the defense's expert witness testified that she did not believe that, taking into account all of the evidence, he was in fact intellect.
Sure, that's the point of an expert. They look at the test scores, they look at all the information, and they make this determination. So sometimes it's not helpful to have categorical rules that impinge on that assessment.
I think I think we have to be mindful, as this court, members of this court have frequently reminded us, that clinicians determine clinical evidence, evaluate clinical evidence, and courts apply the law. In this case, we have a law announced in Atkins that someone with this condition may not constitutionally be subject to capital punishment. There is no court that I'm aware of that has simply said there is no there is a other than Oklahoma, there is a categorical rule. When and if a court in Alabama or elsewhere is presented with an argument that there should be a categorical rule, or that state law incorporates and the Eighth Amendment permits a categorical rule, that will be for the lower federal courts and perhaps this court to evaluate.
Thank you.
Thank you, counsel.